now we've illustrated we've acted diligently, but it still did not lead to successful prosecution. So the blame for and accountability can't be squarely laid at the feet of the police on these facts, my lord. Clearly we've investigated, we've handed over the dockets. It's the NPA's responsibility to ensure that the criminal justice system now runs its course from that perspective. And in regards to the applicants stating that the Minister of Police has taken a stance of a spectator as opposed to investigating crimes. My lord, if we look at the general principles, the general principles of what is provided for related to investigations by the European human rights. It's first that the investigation must be capable of firstly ascertaining the circumstances in which an incident took place. That goes hand in hand with reporting. So you can't come to court and say the police didn't investigate when you don't even tell us that you've reported. That simply doesn't follow. My lord, I'm reading that from my heads of argument. Sorry, I apologize. Even the AK matter is dealt with in paragraph 43 of my heads of arguments. The issue of the European Court of Human Rights and the principles in relation to investigation is dealt with in paragraph 44, where it speaks to ascertaining the circumstances in which an incident take place. And this is why it's everyone's obligation to, when you witness a crime, when you encounter a crime, to report a crime. This is so the incident can be, under the circumstances, be pinpointed at the very least to lead to investigation and further lead to identification and punishment. So on several occasions, based on the applicant's own papers, there's no evidence that any of the victims laid any complaints, in particular to Jabavu, Maboneng, and Jepi, where it is alleged that the police did not investigate claims. And where so claims were laid, or where the applicants were turned away as they allege in Jepi, again, my lord, we are of the view, if we have regard to the principles as laid out in the Oak Bay, Minister of Finance versus Oak Bay, that is also in our supplementary heads of argument, which deals with the requirements of a declarator. There has to be, at the very least, the existence of a dispute. A dispute can exist by any means. So if they had laid these complaints with IPID, that dispute would exist. But we find out now through court papers that these issues had arisen. In addition, my lord, as I previously indicated, the availability of alternative remedies. Once again, there's an alternative remedy. To that end, my lord, the SAPS has detailed numerous instances where it investigated complaints, where it has acted diligently, and where it complied with its constitutional obligations. This court is not at liberty on these facts to come to the aid of the applicants to grant this declaratory. The SAPS doesn't act in a vacuum, unfortunately, and what they're trying to do is bound the SAPS as a nation to a few incidences that had transpired in Johannesburg. Unfortunately, my lord, that's impermissible. There's simply not enough evidence for your lordship to come to the conclusion that the SAPS had failed in its constitutional obligation to investigate and combat crimes in relation to foreign nationals. My lord, and then also I'll briefly deal with the issue of the uniforms, because it is also dealt with in this under this umbrella for the SAPS. So, my lord, if you have regard to what is the SANDF Act, the SANDF Act makes it clear the defense uniform is highly regulated. The Act speaks of a distinctive marking and crest, not merely camouflage or apparel resembling military outfits. So on that score, my lord, it doesn't follow that this is unjustified. At best, the SANDF is best placed to identify what is strikingly similar to their uniforms, bearing regard to the watermarks and the crest that is required. And throughout the applicant's affidavit, they speak of that members of the first respondent always show up in T-shirts and camouflage or military outfits, uniforms as they state, because the Act, Section 8A, states that no person shall wear any form of apparel resembling any of the uniform worn by members of the SAPS and the SANDF. This provision is akin to the provisions in the SAPS Act, which deal with impersonation. The purpose of the provision is to eliminate confusion and impersonation of officials in state authority. Now, my lord, there's never been any confusion on the papers that at any given moment, whether or not the members of the first respondent were acting with the necessary authority of the SANDF or where they were confused for the SANDF. At any given moment, they were always identified as members of Operation Dudula. There was never any confusion to that end. The SAPS in this paper state correctly that camouflage is unfortunately readily available in all the shops, and they simply cannot arrest anyone for wearing camouflage. What we need to establish is whether or not the wearing of that camouflage constitutes the uniform resembling that of the SANDF. And even on the examples of pictures that were provided by the applicants, there's no such. In the pictures, my lord, as you will see when you go through the papers, especially from Annexure 42, yes, my lord, you'll get at pocket 022331. That's where your lordship will find it. But my lord, I'll just briefly show you. My lord, from the pictures, if we look at Annexure 42, there's one person there in the front wearing a camouflage hoodie, and he's wearing a hat. That's not a military hat. The people behind him are all wearing white T-shirts, and some of them are wearing camouflage caps. At Annexure 43A, my lord, these ones aren't even wearing camouflage. They're wearing a camouflage hat with jackets, just black and white jackets. I suppose the most daunting one would be the one that they've attached at Annexure X44, which is in Tlantalax, where he wears a camouflage hat and a brown bomber jacket. That is not akin to a military uniform, my lord. They have attached the evidence of a military uniform at paragraph in Annexure 51. There's no confusion under the circumstances. So yes, the SAPS should, in terms of the Gatherings Act, if it finds that the uniform that is being worn strikingly resembles that of a SANDF uniform, should definitely take action. But on these facts before the court, it simply could not do that. So in that regard, my lord, they failed to make out a case for the relief that is sought in terms of the Gatherings Act. But even if they succeeded, my lord, how would it be applied? Even if they were to succeed to say that camouflage strikingly resembles military uniform, how would it be applied? We know of several organizations that also, unfortunately, wear camouflage, which is akin to hunting gear and the farming activities. That's all part and parcel of camouflage and being readily available. But on the papers, there's simply no confusion or any kind of inference that can be drawn that the conduct or the apparel worn by the first respondents strikingly resembles that of the SANDF uniform. That is not on the papers, my lord. And on that basis, the SAPS cannot simply arrest anybody that is wearing camouflage. My lord, those are my submissions in respect of prayer 8 and prayer 9, and to a large degree, maybe prayer 6. Prayer 4, my learned colleague will now deal with the outstanding issues in relation to the SAPS. I think there's only one outstanding prayer in relation to us.
The court pleases, my lord. My lord, in respect to the relief sought in prayer 4, I just want to emphasize one thing. It's in relation to Section 104(5) of the Defence Act 42 of 2002, which states, any person who, without the written authority of the Chief of the Defence Force, possesses or wear any uniform or part thereof, distinctive mark or crest that has been determined, that's what I want to emphasize, my lord, that has been determined by the Chief of the Defence Force as official attire in the Defence Force. My lord, as the pictures were shown by my colleague, Ms. Isaacs, there is no resemblance of the camouflage attire worn by members of Dudula and those of the SANDF. My lord, and in these pictures, I think it's KX 56, my lord. The applicant attached the pictures of the soldiers in the defense uniform, my lord. And if one has regard to the pictures, my lord, there's no resemblance, none whatsoever, my lord. My lord, just by way of an example, not that I'm arguing from the bar, I've got a camouflage cap. You can buy it anywhere. I bought it from Jeep, and I embroidered it because I'm a member of the Jeep Club, Limpopo Wranglers Jeep Club. So if I find myself in the midst of the members of Dudula, then I'll be arrested and be guilty of wearing that cap, my lord. So that cannot be correct, my lord. Then, my lord, my learned colleague, Advocate Mukari SC, dealt with the issue of the interpretation of Section 41 of the Immigration Act. My lord, we align ourselves with the submissions, also with the submissions relating to the interpretation in respect of the minor children, my lord. So, my lord, what I'll do, I'll just take it from where he left it off, my lord. And deal with the my lord, deal with the just a moment. Deal with the comparative, my lord, with other countries, my lord, of the application of or the powers entrusted in the immigration officials, my lord. In our case, my lord, we refer to Botswana as the first country. My lord, that is contained in our supplementary submissions, start from 09-239, my lord. That's where we're dealing with the comparison with other countries, my lord. Just a moment, I'll get there, my lord. start from paragraph 3809-251, my lord.
No, paragraph 37.
My lord, in Botswana, the powers of officials are set out in Section 6 of the Immigration Control Act, which provides 6. Examination of suspected illegal immigrants. 1. A police officer or traditional authority who suspects that a person is an illegal immigrant may at any time require the person to present himself or herself to an immigration officer and submit an examination. 2. Notwithstanding the provision of subsection 1 and subsection 307, 1 of the Criminal Procedure and Evidence Act, a person who admits to being an illegal immigrant shall pay to a police officer an admission of guilt fine or of not less than 300 pula, but not more than 10,000 pula. 3. A person who is required under this section to submit to examination shall be examined by an immigration officer in accordance with the provision of Section 5. My lord, at paragraph 39, in Namibia, the powers of the immigration officials are set out in Section 8 of the Immigration Control Act as follows. 8. Powers of immigration officers in respect of certain persons presenting themselves, 1. For purpose of ascertaining any matter referred to in Section 7, an immigration officer may require any person referred to in that section, A, to answer in writing or otherwise such questions as the immigration officer may put to him or her, which are relevant to his or her identity, citizenship, or country of origin, as the case may be. B, to make and sign a declaration in prescribed form. C, produce documentary or other evidence relevant to his or her claim to enter or be in Namibia, or that his or her entry into or his or her presence within Namibia will not be unlawful. D, to submit to any examination or test to which such person may be subjected under this Act. E, if it is suspected that such person is afflicted with any disease or physical infirmity which under this Act would render him or her a prohibited immigrant, to submit an examination by a medical practitioner designated by the minister. 2. Any declaration made by any person under subsection 1 shall, notwithstanding anything to the contrary contained in any law relating to stamp duty, be exempted from such stamp duty as may be imposed by law in respect of affidavit and solemn or attested declaration. Section in paragraph 40, my lord, section 4, United Kingdom Immigration Act provides information and documents. 4.1, it shall be the duty of any person examined under paragraph 2 or 3 above to furnish to the person carrying out the examination all such information in his possession as that person may require for the purpose of that or any other person's function under that paragraph. 2. A person on his examination under paragraph 2 or 3 above by immigration officer or on his examination under paragraph 3 above may a designated person shall, if so required by an immigration officer or designated person, A, produce either a valid passport with photograph or some other document satisfactory establishing his identity and nationality or citizenship, and B, declare whether or not he is carrying or conveying or has carried or conveyed documents of any relevant description specified by the immigration officer or designated person, and produce any documents of that description which he is carrying or conveying. In paragraph B, relevant description In paragraph B, relevant description means description appearing to the immigration officer or designated person to be relevant for the purposes of the examination. My Lord, in paragraph 41, in addition, the UK Act stipulates an immigration officer has the authority to request any person examined to submit to further examination through written notice. This further examination may include verifying the individual's identity, any entry legality, compliance with the leave condition, and any prohibition or restriction on their return. At paragraph 42 of the heads, my Lord, we're saying when one examines the scope and upon immigration officials and members of the South African Police Service, it becomes evident that these powers are no more burdensome than those granted to the immigration officers in our neighboring countries, powers which are similarly not limited to public spaces. Accordingly, the purpose of Section 41 is to enable the verification of individuals who are present in the country without valid identification or documentation. In such instances, their presence is deemed unlawful, and it is appropriate for law enforcement authorities to exercise their powers not only in public spaces but where necessary in private ones as well. My Lord, paragraph 42 is saying, put differently in terms of immigration legislation, which must be read together with and in uniformity with other accompanying instruments. A foreigner must prove their right or entitlement to be in the country. Now that entails furnishing the relevant authorities and including members of the South African Police Services with identifying documents such as passport. In case where one is dealing with refugee, the Refugee Act kicks in, and one may provide the relevant document in terms of the Refugees Act. That is, there is a positive requirement imposed, and a failure to comply with this positive obligation attracts legal conclusion of non-conformity. That is a legal deduction one is presumed to be unlawful in the Republic. My Lord, those will be the submission in addition to the interpretation of Section 41 in comparison to our neighboring country, my Lord. As the court pleases, those will be our submissions. Thank you.
Lord, it is necessary to address the submission of two sets of respondents, some aspects of reality, a fairly sprawling set of releases. We shan't repeat anything we said in our private submission. We'll are at the heart of this matter. Lord, we propose to address 7 issues in reply, some very briefly. The first is the non- approach of the Director General in the affidavit. Failures to investigate and prosecute. There were some concessions made here belatedly on behalf of the SAPS, but the SAPS has failed in its obligations to open cases and investigate them in certain instances, in particular the Jeppe police station incident following the eviction at Msibi House. But, my Lord, what characterized my learned friend's submissions throughout on this issue on behalf of the SAPS was selective invocation of examples where the SAPS either was not present or did act. The overall pattern, my Lord, on the papers is overwhelming, and it's set out in our supplementary note which tabulates the papers. It's an overwhelmingly supine response which culminates in the evidence. It was part of the murder of Mr. Nyati. It's part of most of their conduct in the hospitals, at the schools, and so on. And in Prayer 2, my Lord, we seek an interdict against that conduct. Prayer 1 is the declarator that lays the foundation. And so we submit that Order 2 is vitally necessary to protect the rule of law in relation to who may exercise the Section 41 powers. My Lord, I must then deal with the responses now raised in relation to the constitutional challenge to Section 41 by both Home Affairs and the SAPS. Again, my Lord, we listened with care, not a word on the Minister's letter, to which I took your Lordship in my main submissions, regarding the use of Section 41 across 4 areas in Johannesburg to conduct joint operations without warrants. And, my Lord, not a word on the SAPS letter defending, justifying the detention of Miss SN, the 15-year-old citizen minor, saying we did this in terms of Section 41 because Section 41 authorizes it. Lord, what we now have from the Department of Home Affairs is that your Lordship must interpret Section 41 to contain all of the constitutional protections about which we complain. At the outset, my Lord, I emphasize that even if they're correct, we say they're not. But even if they're correct, we submit that that is a basis for the declaratory order that we seek in the alternative, that Section 41 includes all of these elements, that it requires a warrant, that it doesn't apply to children, and that it requires a reasonable suspicion. So even if they're correct on that argument, our alternative relief we submit in oral argument is that children shouldn't be dealt with under this legislative scheme. They should be dealt with under the dedicated legislative scheme which has been enacted to provide for children. Not that Section 41 can be interpreted in that way, that we shouldn't even be looking at it. It shouldn't even be in the picture when we're dealing with children. And, my Lord, their submissions ultimately, the Human Rights Commission, which we associate ourselves with, are that it would strain the language of Section 41 to interpret persons, which is the word in the section, to exclude children. And my learned friend relied on the Abaflali and Moyo decisions in that regard. We have nothing to add there. My Lord, my learned friend, again for Home Affairs, gave an example, using himself in the example, of, well, if I arrive in the country, of course I must be expected to present my passport and answer questions about who I am. My Lord, that's precisely the point. That at ports of entry, powers of that nature are appropriate, and quite a different matter from Section 41, that is completely unrestricted as to time, place, or persons. It's a power that can be used anywhere, against anyone, and on whatever basis, or no basis. And my Lord, the SAPS, in their heads of argument, persisted with the submission that Section 41 must also be allowed to be used in private. In other words, my Lord, in people's homes, places of study and work. That that's legitimate, it's necessary. Without a warrant, my Lord. We submit that that cannot pass constitutional muster. And my Lord, in relation to this issue of warrantless raids, my learned friend for Home Affairs says, well, that's not what Section 41 is intended to do. That's not its purpose, to allow warrantless searches or raids. So why are we even bringing it up? Well, we're bringing it up, my Lord, because that's precisely what it's been used to do. On the Minister's own confirmation, in Operation Restore, across the 4 areas in Johannesburg, and the Minister says, well, I don't require a warrant, and no one has challenged the constitutionality of Section 41. Well, we are now, my Lord. My learned friend also referred to the obligation to assist, and again gave the example that, well, if the person is just unlucky, they happen not to have their ID on them, then the police must drive them to their home, the immigration officer must drive them to their home and enable themselves to identify themselves. My Lord, that aspect does appear in the provision, but there's a crucial point here, my Lord. It only kicks in once the person has been detained. It's in the latter part of Section 41. So the request comes, the learned friend submits that there's a duty to answer it. Yes, there is, on pain of criminal prosecution. It's an offence not to answer the questions. You may then be detained, and only once you've been detained, my Lord, does that obligation to assist the person apply. My Lord, we saw what happened with Miss SN. In any event, she borrowed a cell phone from another adult in custody with her to make the call to get her uncle to come and secure her release. But my Lord, there is no protection in that regard built into Section 41. It comes too late. You're already in custody. Lord, there's reliance also on Section 33(5) of the Immigration Act, which deals with obtaining a warrant to conduct a search. Lord, we understand the submission to be that, well, frankly, my Lord, there appear to be 2 different ways to understand the submission. I'm not entirely sure which it is. The one is you must read Section 41 with Section 33(5). The other is that, well, Section 33(5) is the provision that applies when you're dealing with warrantless raids or searches. So Section 41 isn't even in the picture. We've shown that Section 41 is in the picture. It's being used to do precisely that. But, my Lord, in relation to the other interpretation that you must read the 2 provisions together, Section 33(5) is prescriptive about what purposes it applies to. So, in other words, when can you apply for a warrant as an immigration officer to search premises? And those are listed in the sub-paragraphs. And none of those, my Lord, involves requesting a person to identify themselves in terms of Section 41. In other words, Section 33(5) simply doesn't apply to that function. It applies to other functions, seizing articles, arresting a person who's illegally in the country, who's already been determined to be illegally in the country. So, my Lord, there's no challenge to Section 33 in these proceedings, or to any of the other provisions that my learned friend for Home Affairs relied on. The problem is Section 41. And that problem is not cured by Section 33 or any of the other provisions of the Act. My Lord, a brief word then on the foreign law relied upon by my learned friend for the police. We dealt with it very briefly in our main submissions, and I'll attempt to be brief again. They rely on Botswana, Namibia, and the UK. Lord, in relation to Botswana, the simple point is that that procedure requires notice first. The person gets summoned. It doesn't allow immigration officers to walk our streets or enter people's homes to compel them to answer information or identify themselves. So that's Botswana. Namibia, my Lord, we made the submission yesterday. They rely on Section 8 of the Act. Section 8 of the Act, my Lord, refers to a person presenting themselves in terms of Section 7. And my Lord, Section 7, which they don't quote or refer to your Lordship, provides a person seeking to enter Namibia shall, before entering Namibia, present himself or herself to an immigration officer at a port of entry. So, my Lord, all of those powers and the consequences that flow from them that they referred to in Section 8 of the Namibian Act refer to people, as in my learned friend for Home Affairs example, arriving at an airport, standing in the queue and being required to answer questions there. Again, not in your home, not on the streets. Lord, there's one further point in relation to Botswana. There's a further jurisdictional requirement there. Before the person is summoned, the person must be suspected to be an illegal immigrant. So again, it doesn't apply to everyone and anyone at random. It applies to a person already identified by the authorities. Further point in relation to Botswana. Finally then, my Lord, in relation to the UK, they rely on the United Kingdom Immigration Act. They purport to refer to Section 4 of that Act, my Lord. That's an incorrect reference by the SAPS. Section 4 of the UK Immigration Act doesn't contain the provision that they quote. That provision appears, my Lord, in Schedule 2, paragraphs 2 to 4 of the UK Immigration Act, and in fact of an earlier iteration of the Immigration Act that's since been amended. But let's deal with it as it was in 1971. My Lord, the UK Act basically also applies to people arriving at points of entry. Its Schedule 2 is headed Administrative Provisions as to Control on Entry. So, my Lord, again, it applies to people who are presenting themselves either at a land border or at an airport, and really doesn't avail us. And in fact, my Lord, we made the submission. It demonstrates why Section 41 is constitutionally problematic, because we have always accepted, my Lord, that there is a legitimate purpose to Section 41, requesting people to identify themselves, but only in the appropriate, constitutionally appropriate circumstances. And we've made the submission, my Lord, that three crucial safeguards are missing from the provision. That it should only apply to public places, which would include ports of entry, that it shouldn't apply to children, and that it requires a reasonable suspicion or some other requirement of reasonableness at that first stage of making the request. My Lord, we submit that the language is simply not capable of being interpreted to include those protections. My learned friends for Home Affairs say that the court should interpret person to exclude children, and interpret silence to mean with a warrant. And with respect, my Lord, that simply stretches the court's interpretive muscles beyond what they're capable of achieving. So those are our submissions on Section 41. The provision is clearly unconstitutional, and it's necessary for the court to exercise its powers to declare it inconsistent with the Constitution to the extent of its unconstitutionality. We've proposed a reading in to remedy the three defects. In any event, my Lord, the order will have no force and effect until confirmed by the Constitutional Court, and we include referral in the order. My Lord, remains to deal with three issues somewhat more briefly. On the National Action Plan, my Lord, there's no meaningful opposition, my Lord, we submit with respect. There's again reference to the Hate Crimes Act having been passed. We've made the submissions, it's not in force. In any event, it's not an answer to what the National Action Plan is required to do. And my learned friend referred to that part of our founding affidavit where we appropriately acknowledged that some aspects of the National Action Plan have been implemented. But the bulk of it, my Lord, has not been implemented. There's been a failure to take reasonable steps to implement it, including those three crucial aspects that we highlight: the early warning rapid response mechanism, the disaggregated data, and the third aspect that we highlight, my Lord. And, Lord, separation of powers simply cannot avail the respondents in this regard. It's their policy. It's their policy, and they've failed to implement it even in the time periods. The time periods are not even ours, my Lord. They set their own time periods, a 5-year period, to implement it, and they've still failed to do that. This is as far from intruding into the separation of powers with respect as it's possible to get. And as to whether the order is necessary, my Lord, it is necessary because they've failed to do so. They've failed to implement those aspects. The court order will be a necessary and vital corrective, guidance to the state to discharge its constitutional obligations by implementing its own National Action Plan, also necessary to discharge South Africa's international obligations. And my Lord, my learned friend Mr. Mpofu, for one of the amici curiae, for the ICJ, referred to South Africa's commitments in Universal Periodic Review before the Human Rights Council, where the state committed on the international plane to implementing this very National Action Plan, my Lord. And concern was raised in the UPR over the state's failure to do so. So there's an accord here between the international plane and the domestic, my Lord. And the state has already committed domestically and internationally to implement it. Lord, then dealing with military uniforms, and again we can be relatively brief on this, my Lord, starting with issues of resemblance. Both of my learned friends for the SAPS now made oral submissions, taking your Lordship to a very small selection of the photographs, that there is no resemblance. First of all, my Lord, we've been called up on Plascon Evans, and we submit that we've respected its rules, but there is no denial of resemblance in the answering affidavit. The averments are pertinently put, my Lord. I'll provide the reference in the founding affidavit, pages 03-59 to 66, paragraphs 153 to 162. And this is dealt with, or rather not dealt with, my Lord, in the answering affidavit at page 06-18 at paras 90 to 92. And my Lord, the averment is pertinently made in the founding affidavit that the uniforms and clothing worn in the images resembles that of the military, and there is simply no answer to that paragraph in the answering affidavit, to paragraph 154 of the founding affidavit. They just skip it. So, my Lord, it was never put in dispute by any party on the answering papers that the uniforms resemble each other. So, my Lord, the position on the papers is that resemblance is apparent. My learned friend, Ms. Isaacs, picked 4 examples to show your Lordship where she suggests there is no resemblance. My Lord, with respect, they've picked the examples where which best suit their case. We've put up over 30 images of the uniforms being worn. And a proper consideration of those over 30 images, my Lord, confirms the resemblance, which was never put in dispute. So, my Lord, it's a belated point which has no basis on the papers, and which this court cannot sustain. There was an additional inflection added to it in oral argument by Ms. Isaacs on behalf of the SAPS, which is that she used the word strikingly that the uniforms don't strikingly resemble that of the military. She used it repeatedly. There's no such requirement in the Gatherings Act, my Lord. The language is resemble. My Lord, there's one further vital contextual submission here, which is that the facts here are gatherings by Operation Dudula, which the papers confirm are associated with widespread threats, what my learned friend for Home Affairs described as crimes, and where, on certain instances, the members of Operation Dudula are armed, for example, at the Musibi House eviction. So, my Lord, with respect, the glib example given by my learned friend for the SAPS of he himself wearing a camouflage cap and fearing being arrested for it ignores the context entirely, and we submit fails to have any sensitivity for the context and its effects on people. We're not talking about any of us advocates wearing a cap in a shopping mall, my Lord. We're talking about gatherings which are loaded with threat. And my Lord, so that example is entirely unhelpful. My learned friend, Ms. Isaacs, asked the court the rhetorical question, well, how should we implement this? We've already made submissions on that, my Lord. It's very straightforward. We've never argued that there must be widespread arrests or the police should wade into every gathering and arrest everyone who may be wearing camouflage clothing. It's simply instructing them not to do so. A single letter might have sufficed, my Lord, given that there's a single entity convening all of these gatherings. One letter from the SAPS referring to Section 8 of the Gatherings Act and saying that it's unlawful to wear clothing resembling military uniforms and you're instructed to desist from doing so may have sufficed. They did nothing, my Lord, absolutely nothing at any point. And an order to that effect is accordingly necessary, my Lord. Not only declaring that the wearing of military uniforms by Operation Dudula was unlawful, but also in relation to the SAP's failure to address it. Lord, the final theme then that I must deal with in closing, and perhaps appropriately so, concerns human rights defenders. My Lord, this issue arose in the context of my learned friend for Home Affairs' response to the amicus curiae, the UN Special Rapporteur for Human Rights Defenders. And my learned friend made the submissions that amici must confine themselves to their appropriate role, making submissions on the interpretation of the law, domestic and international, but not introduce new evidence and not seek new relief. Lord, there are a number of instances where, in fact, amici have suggested relief, and we submit that is an appropriate role. Not to introduce fundamentally new relief, but to make submissions on the relief sought by the parties. That is an appropriate role for amici. But more fundamentally, my Lord, it was submitted by my learned friend for Home Affairs that, quote, you will not find anything on the papers on human rights defenders being attacked. And my Lord, perhaps this begs the fundamental question, the starting point, what is a human rights defender? And my learned friend, Mr. Bhima, has addressed this to some extent in his written submissions. But in essence, my Lord, a human rights defender includes an activist, be a faith-based leader.
My Lord, I'm going to object to my learned friend giving evidence on behalf of an amici from the bar. If you look at the affidavit of that amicus curiae, it never tells you what he means by human rights defenders. So it's not open to my learned friend to start now arguing that case. And in his submission, he never made any case about human rights defenders, that their case is based on human rights defenders. And amici was here to assist the court, not to assist him. So as a purpose.
Let me just make this point that you made certain submissions, and I've obviously noted what you said there, Mr. Mukari. I'm now hearing submissions from Mr. Bricchio. Again, I'm going to hear those submissions, and I'll have to decide on the basis of what the legal position is. But I've heard your submissions, and yeah, the role of amicus is obviously clearly defined in our law, and whether you're right or whether Mr. Bricchio is right is something that I'll have to decide on.
There's a cut, please.
Well, the objection is without substance. And a human rights defender is defined in an international soft law legal framework. It's law, my lord, not evidence.
Yes.
And that's what the amicus has put up, which is that international legal framework. It's that framework under which that special rapporteur operates. It's got nothing to do with facts. My lord, we accept that an amicus ordinarily cannot put up new evidence without leave of the court. It's not our understanding that they've sought to do so. The point I was about to make, my lord, is that the founding papers are replete with evidence of threats and attacks to human rights defenders. What is a human rights defender, my lord? In terms of the law, it's an activist or a lawyer. It can be a faith-based leader, such as an imam or a priest, who plays that role of on the ground, stepping in to represent the rights and interests of people whose rights are threatened. It's a legal term, my lord. We didn't use the term, but it's a term that exists in international law. And my lord, the papers, I can give some references. The key section, my lord, is that section of the founding affidavit which laid a basis for the Part A order, which is begins at 0313 and runs from paragraphs 26 to 35. And your lordship will recall the evidence that's set out there that I didn't deal with in my main submissions, my lord, which is, if we start with the lawyers, the threatening calls to the applicant's instructing attorneys, threatening to subject the applicant's instructing attorneys and candidate attorney, who are women, to sexual assault and violence, the threats that culminated in the applicant's attorneys having to close their offices on several occasions. And Lord, those are Lord, I haven't placed this on record, but there was a previous junior counsel who acted in this matter with me. That junior counsel withdrew because they were afraid of the threats.
This guy.
I placed that before the court as an officer of the court. My Lord, the threats go far beyond the lawyers, and my Lord, the lawyers are usually the least at risk in these situations. The people really at risk, my Lord, are the members of the four applicants from Kopanang, Saitif, the Inner City Federation, and Abahlali Basenjondolo, who, my Lord, and those incidents, those threats are all set out in that section of the affidavit and throughout the rest of the affidavit, including threats to cut one of the Kopanang leaders and let that person bleed out in front of their child. So, my Lord, the suggestion that there's nothing on the papers involving threats or of attacks human rights defenders is with respect unfounded, my Lord. It took courage for those four applicants and the 30 deponents to the affidavits to place themselves before this court, my Lord, to put evidence before the court of the events that have been unfolding. And Lord, they do so in order to seek this court's discharge of its constitutional function to protect their rights and the rights of other vulnerable persons in our communities in the face of what my learned friend has described as crimes, brazenly, blatantly, widespread unlawful conduct. And ultimately, my Lord, to vindicate the rule of law. Lord, the applicants submit that a case has been made out for all of the relief sought in the draft order. Those are our submissions.
My Lord, with your permission.
Sorry, my Lord, if I may, there may be one further submission from my juniors. I perhaps went through. Apologies. My Lord, I've been requested to place on record that There is a member of Operation Dudula present in court who is currently taking photographs of the persons present in court, including legal representatives, without their consent, and posting those on social media. I simply place it on record.
If that is happening, I should ask whoever is doing that to immediately stop that and delete those photographs.
Lord, apologies, she's actually left the room after I asked if I could see if she is taking photos. She's left the courtroom, so she's not here right now. But I assume those in court will inform.
My Lord, just with your indulgence, I just want to deal with one aspect which arose in reply, which is a new matter because it's not an issue that we had an opportunity to argue. Because my learned friend, in argument in chief, he said Plascon events doesn't apply to their case, you shouldn't apply it. Now in reply he says that it should apply, but then he says that in respect of the prayer on collusion, then the court should grant any other relief, which we have not been told what it is. So I'm just saying that it is not appropriate that in reply, then the case changes now to something else which we never had an opportunity to deal with. So your Lordship will just take into account those submissions.
Sorry, Mr. Mukari, I understood Mr. Brickhill to accept
Yes.
that, especially when it comes to the factual assessments and trying the facts in the matter, for starters, Plascon Evans is being developed, that principle.
Yes, absolutely.
Over with Whitman
Yeah.
and
Yes.
the other matters.
Yeah, that's what he was arguing in reply. So that's the point that, we never had an opportunity
Did he
to
say something
deal with.
different in his main argument?
In his main argument, he said that then you shouldn't apply Plascon events because this is not a commercial matter, it's a constitutional matter.
Well,
So
if he
just
did
making
that,
that
I'm sure
point.
he's
Yeah.
not persisting in it. But I think that the point is taken. I
Yeah.
understood and I needed clarity on this issue. That when it comes to making an assessment of the facts in the matter, that Plascon Evans applies here.
Yes. No, absolutely.
Irrespective
Absolutely.
of whether or not we're dealing with the constitutional
Yes.
matter or
Yes.
not, you still need to establish
Then
a
to
basis,
exactly,
factual
absolutely.
basis
Yeah.
on which we apply the law and or whether or not constitutionality is challenged.
No, you're absolutely correct. So that's why I had to argue Plascon events, which I didn't have to ask. I didn't have to argue it when I was arguing because of his submissions in chief. But then the concession, of course, is well made. But the point I was making was that now results in having to him argue the case to defend the position which he was not defending in chief, which he never had an opportunity to do, and to even say that now the court, in respect of the collusion support, the court then can just give any other order that it wants to do, which we are not even aware of what it's talking about. So I'll just bring that to your attention.
Thank you.
Thank you. There's a copy.
I want to thank you and Mr. Brickhill, all of the other council and your teams, obviously for those who heads of argument and for the submissions made during the hearing of the matter. Needless to say, I've been given a lot of food for thought and I need to mull over what has been said here today. For that purpose, I intend reserving my judgment and postponing the special motion sine die. As soon as we're ready to hand down the judgment, we'll let the attorneys know that we are ready and advise them of the date and time on which the judgment will be handed down. So for now, and in sum, the special motion is postponed sine die for my written judgment, which is hereby reserved.
As the court pleases.
As the court pleases.
Yes, thank you everybody. Court adjourned.